Good afternoon, good morning, depending on where you're calling from, joining us from. Welcome to the second day of our 3-day virtual annual conference and to the third session of the conference. The topic for this session is gender mainstreaming, specifically in regional courts and tribunals in Africa. So we're very glad that you could join us. We're seeing the numbers going up steadily, but let's not delay those who have joined on time. So as usual, let me start with the logistical announcements. Interpretation is available. The conference is running in 4 languages: Arabic, English, French, and Portuguese. So please, if you look at the bottom right hand of your screen, you will see the icon for interpretation. So please click on it and choose the language of your choice. We also ask participants who have joined, I can see most have met the request that we did, but that you join in your name. So please don't join as iPhone user 6 or Android user 7 or something. Please join in your name. If your name is not there, if you click against your participation on the participant list, if you double click on it, you'll see the 3 dots. It will enable you to type in your name properly, so we have you with your proper name. We also encourage you that we want to make the conference as interactive as possible. So please use the chat function robustly. And also the question and answer function. If you have a specific question, please type it into the question and answer function, but otherwise for comments, for other issues and so on, for ideas, for your own experiences, use the chat function. And we'd encourage you to start now, but at least typing into the chat function who you are and where you're joining us from. So your name and where you're joining us from. And then we also request all participants to remember to mute your audio unless you've been given permission to speak by the moderator. We also encourage you to check in on the PALU social media. We are available and prolific on Twitter, on Facebook, on LinkedIn, and also on YouTube. All of them going with @AfricanLawyers. So throughout the conference, in between, in the evenings and so on. You can also find us on social media. So welcome. The moderator of this session is the PALU treasurer, Ms. Gigi Reed-Miles. She was having a spot of internet connectivity trouble earlier on from Swaziland. I don't know if it's improved now, Ms. Gigi, and you'd like to take it up from here, or we just start and you join us as we go along. Can you try, Gigi, to take up from here?
Hello?
Hello, we can hear you.
Oh, great. Good day, everybody. We are in Swaziland, and I am absolutely pleased to be chairing this session. I have panelists of amazing caliber, and we are going to be discussing a very important and interesting subject. I welcome our presenters, and as I've said, I'm honored to be your chair today. And maybe to introduce myself primarily, I'm Gigi Reed-Miles. I'm sure, as you've seen, I'm the treasurer for this esteemed organization, the Pan-African Lawyers Union. And I am a practicing attorney in Swaziland, a small little country way down the bottom of Africa, which I must welcome all of you to someday. Now, maybe not to waste any of our precious time, panelists, please, let's take into consideration that we are strictly limited to 10 to 15 minutes for your primary presentations. I'd also like to encourage all the participants and welcome to all of you to use robustly our chat box and the question and answer box throughout this session. I would also then, I think, maybe move straight into introducing our panelists. I would like to introduce them as and when they begin their presentations. And I want to start by introducing our lady judge, Mrs. Monica Kaligira Mujeni. Our lady judge, Ms. Mujeni, as an introduction, was first appointed judge of the East African Court of Justice in the First Instance Division in December 2013. And I'm told and I've read that she was the first lady judge on that bench. She was elevated to be principal judge in July of 2015, in which position she continued to serve until the 30th of November 2020, when she retired from the court at the end of her term. She's also the chairperson of the East African Development Bank Staff Appeals Tribunal, and this was from 2013 to date. In October 2019, she was appointed to the Court of Appeal of Uganda while she was still serving at the East African Court. She has served as a judge of the High Court of Uganda in the Land and Criminal Divisions from 2010 to 2015, when she took up her full-time residential position at the East African Court. She had previously held senior positions in legal and corporate services in a range of government corporations, including the Uganda Road Fund and in the Divestiture and Reform Implementation Committee and in the Privatization and Utility Sector Reform. Before that, she was state attorney and then senior state attorney in the Attorney General's Chambers, Uganda. Now she holds a Master's of Laws degree in International Trade Law from the University of Essex, a postgraduate diploma in legal practice from the Law Development Center, Uganda, and a Bachelor of Laws degrees from Makerere University, Uganda, and she's an advocate of the High Court of Uganda. And she has been defined, and comments have been made about Our Lady Justice Mujeni in this fashion, that throughout her career, Lady Justice Mujeni has been able to demonstrate leadership skills. She has a strong, results-oriented work ethos, exemplary integrity, professionalism and accountability, an excellent communicator with interpersonal skills, and a formidable team player. We are honored to have you on my panel and in this session, Lady Justice Mujeni.
Thank you very much, Gigi. And good afternoon to my fellow panelists. I don't know whether this means I need to start my presentation. I'll wait for a signal.
Yes, absolutely. Please proceed.
Okay, I have a PowerPoint presentation, which probably won't be picked, but I shall simply highlight a few salient areas. So if you bear with me, I'll quickly go to it. Okay, in a nutshell, I thought I needed to introduce the subject with some sort of background information about what regional courts, especially within the African continent, are about. I think basically they are engines of legal integration. For example, the East African Court of Justice has a pivotal role to play in the East African community integration. And as engines of legal integration, they basically develop community law through case law and interpretation of the treaty. Then secondly, that case law that is developed into community law then is integrated both within the national judiciaries as well as the governance bodies of the respective member states of the East African community. My focus in this presentation shall be mainly the East African community and the East African Court of Justice. However, having said that, most regional courts operate against the background, the environmental context of a very weak rule of law practice. African countries have not yet quite embraced the reality of what rule of law is all about. So there are give and takes here and there, but basically it's a very weak rule of law context. Secondly, there is a huge variance between the legal systems applied by the 6 partner states of the East African community. We have the majority applying common law, then there are 1 or 2 that apply civil law, and then 1 state applies Arabic law. Therefore, to get harmonization on legal issues is not always readily forthcoming. And that too impedes the quality of analysis in terms of the jurisprudence coming out of the East African Court of Justice. Finally, and this is fairly sensitive, but it must be said, the region within which we operate is fairly sensitive to political and economic turbulence. The most trade partners of the East African community partner states are external. While there is a lot of trade happening within the region, the bulk of investments come from beyond the region. And therefore the markets are fairly sensitive to economic and political turbulence. And this is something that the court cannot run away from. It must exercise its jurisdiction within that context. There is what has been termed as fairly responsive approach to the reality within which courts operate. In terms of gender, the East African community did formulate a gender policy in 2018 that basically is driven by the following 8 principles. The first is gender equality and equity. Second is gender inclusiveness. Third is women's right to dignity. Fourth is women's empowerment. Then there is good governance, access to justice and equality before the law, prohibition of domestic violence on the basis of gender or nationality, and finally, affirmative action in order to achieve parity. So that in a nutshell is the gender policy of the East African Community Secretariat. There is a bit of a contradiction in terms of the governance because currently the 3 organs of the East African community are fairly fused under the East African Community Secretariat, meaning the East African Legislative Assembly, as well as the East African Court of Justice, have their planning centralized and done under the East African Community Secretariat. That in itself has caused lots of problems in implementation of whichever policy, including gender policy. And as a result, we see many of the action points that arise from the gender policy being restricted to the East African Community partner states and the Secretariat, leaving the organs, for example, the East African Court of Justice, at a loss as to what their specific role would be in engendering gender mainstreaming within the court. Secondly, the centralization of the East African community's governance in the East African Secretariat, East African Community Secretariat, means the court can only play a supportive role, which often is very minor in terms of staff recruitment or addressing any gender gaps that may arise or that it may experience. Secondly, the court has now, to bridge that gap, the court has formulated an East African Court of Justice Administration of Justice Bill, and this bill seeks to relegate the Secretariat's role to support to the court in terms of appointment of judges as well as appointment of staff. It also would be the right avenue within which the gender policy would be implemented because it gives the court the authority to do recruitments and to streamline its own governance and work out the structures under which it would operate. Now, gender inequities at the East African Court of Justice. In terms of gender representation, the court, when it was fully constituted, was comprised of 2 female judges and 9 male judges. As the introduction that was made says, A large number of the judges have since retired, but as at, say, middle of last year, when we were optimally constituted, there were 2 female judges against 9 male judges. In terms of the staff, there are 11 females and 13 males, professional staff being 4 males to 4 females, and general staff 8 males to 8 females. It's fairly evenly balanced at the lower level. So what is our take home on this? It seems to me that at the fairly lower level, there is an attempt to evenly balance the gender representation. However, at policy level is where there is a gap, a clear gap. It is important to note that of the 8 professional staff, the 4 men actually occupy the 4 top positions in administration. Then we come to the court judicial officers, and the judges are skewed significantly towards the male gender. This, as we shall see later, has implications for planning within the court. Now, unpacking the gender issues that arise therefrom, female judges under that sort of environment must of necessity possess a wealth of professional experience to be able to influence policy in any way. If they are not strong in terms of personality, and strong in terms of background experience, and strong in terms of what they bring to the table, their voices are likely to be lost within the male club that the judicial office is. Then secondly, I'm sorry, I'm going to be very candid. Unbridled male ego often impedes collegiality and professionalism in judicial discourse and engagement between judges. So the judicial tenets notwithstanding, there is a way male ego will always come and impede the objectivity of judicial discourse, and that in itself can affect the resultant judgments. Finally, equal treatment for female advocates is significantly enhanced, in my view, with female judicial presence. When there is a female judge sitting on a panel, I think it lends some sort of support to the female advocates that appear before us. Although we have had very professional advocates appear, but there is a tendency for male judges to not quite grasp the issues that are being peddled by the female advocates. They think they are being simplistic or emphasizing a point that they think is not really important. However, women with the background of the egoism that is very rife, even in the judicial service, we tend to be more partial to the female advocates, and we'll give them a chance to have their day in court. With regard to the staff, the male professional staff, as I say, do dominate the decision-making at that level, and the family work balance does not help because most of the female staff leave their family in their home countries, and trying to balance the family work balance often impedes on their performance and the prospects for promotion. And of course, the skeletal staff court organogram leaves little room for career development in terms of affirmative action. Best practices from female judicial leadership in Africa. I would say, from my experience, and I'm focusing specifically now on the East African Court of Justice, there is need for female judicial leaders to focus on the ball and not get derailed by the lots of noise that is often surrounding them. We need to know exactly what we would like to get out of our tenure of service and focus on that so that we sort of create a legacy. Now, in my tenure at the East African Court of Justice, we did introduce an East African Court of Justice Administration of Justice Bill. It is yet to be passed into law, but that's more because of the political aspect of it. It's got to be ratified by the heads of state than the technical aspect to it. That Administration of Justice Bill introduced governance reforms to the bill that would include all judges in policy formulation of the court. In that sense, whether or not a female judge is in the executive leadership of the court, this judge would have an opportunity to have her voice heard in policy formulation within the governance structure introduced in that bill. Secondly, in terms of the specific judicial function, case management, we were given an opportunity during COVID, which we are still exploring, I suppose, to consider virtual court hearings. And the virtual court hearings have served so well that we had continuous judicial hearings right up to the end of November. We did have a gap on account of COVID, but there was continual access to justice for all court users. And this is very important in the context of women who often have nowhere to turn in their partner states. We don't have provision in the court for exhaustion of local remedies. So we have many women that think their issues are not being quite attended to in the local courts, which are, by the way, bogged down by a lot of case backlog. We have these women coming to East African Court of Justice, and the online hearings expedited the possibility of these hearings. In terms of contextual justice, I need to make a bit of clarification here. Given the environmental context within which the regional courts operate, it's important for any female judicial leader to bear in mind that there are social, economic, cultural, and political environments in the region that necessitate functional and not superficial justice. What do I mean by this? The rule of law must be protected by the clear enforcement of international rules. However, member states, partner states, policymakers in our national jurisdictions must be allowed leverage to self-correct or self-regulate. That means the court will lay down the rules as they are and interpret the law as it is, but give guidance to these sovereign states to exercise their sovereignty in a manner that includes self-regulation and self-correction without the court loading it down on them. Now, finally, my final perspective on this is the gender mainstreaming aspect. How can the gender gaps in the East African Court of Justice be addressed? My feeling is to ensure equitable gender representation for East African Court of Justice judges and staff, there must be a deliberate and intentional move to review the appointment of judges and review staff appointments such that the gender balance is achieved. Right now, it's not each country has its appointments silently and presents nominees for appointment by the summit. I think there must be a deliberate effort to have the gender representation addressed at that point, such that when countries are nominating names for appointment, the gender balance has been addressed. And it doesn't have to be addressed specifically in the present appointment, but there should be recourse to what the gender balance has been even in the years past. Secondly, there are demographical considerations that must be factored in employment policies so as to address the gender issue. There are issues, for example, to do with women, female staff. Relocation of a wife or mother to another state for purposes of employment is a lot more difficult than her male counterpart ever faces. A lady would be considering her children and her family and her home, not to mention all the cultural idiosyncrasies that pertain thereto. And so you tend to be faced with a difficulty attracting good female staff to take up these positions. Secondly, most staff, when they are employed, do not find themselves able to cope with the dynamics of working in a foreign country and with people that often do not quite understand the gender issues. We're working in an African context. I'm trying to be careful here. We're working in an African context, and a woman standing up to a male superior and saying, I am not taking this, I'd rather resign, is not something that happens often. So when the courts are faced with employment disputes, I think we need to be careful. We need to be more sensitive to the cultural practices and the social cultural elements that surround most of these issues. It's important to bear in mind that there are women, for example, in the Arabic context, there are certain things that cannot be advanced as forcefully as they can be advanced in other jurisdictions. We have cultures that are linked to religion, and the considerations there are significantly different from cultures that are purely cultural with not much religious indoctrination. So I shall leave it at that. I don't want to get into a controversial subject. I want to leave it at that for now and wait for questions. Thank you very much.
And thank you very much, my lady Justice Monica Mugenyi. I think you have tried to be as polite as possible. Let's hope, because we have other panelists who are not members of a bench at the moment, that they'll be able to take the baton from where you have left it. Now, just first, let me apologize on behalf of the King of Swaziland and the government of Swaziland for their failure to provide good enough internet so that we could, in our turn, have our own Queen, Gigi Reed Miles, moderate fully the session. You could see she had already begun introducing very positive vibe and flair into how she was introducing the participants, and I was looking forward to seeing how she treat the subject of Dr. Robert Eno and Dr. Renifer Madenga. So I apologize on behalf of the King that his internet is not yet good enough. I'd like to skip a bit the sequence as done in the program and go to the African Court on Human and People's Rights first, for a reason that will become quite self-evident when Dr. Madenga comes in at the end. So for now, I'd like to invite Dr. Robert Eno to give us a perspective. Judge Mugenyi gave us a perspective from a regional court. Now Robert to give us a perspective from a continental court. Dr. Eno was first recruited as Deputy Registrar of the African Court on Human and People's Rights, which is also based here in Arusha in Tanzania, in July 2010. He then was promoted to acting registrar 6 months later in January 2011, and confirmed as registrar a year later in January 2012. He has over 16, I think it'd be 18 now, years of uninterrupted work experience in the human rights and related fields, working with NGOs, national human rights institutions, academic institutions, and now with intergovernmental bodies. Before 2010, when he moved over to Arusha to the court, he had been in Banjul at the African Commission on Human and People's Rights, where he did a stint, literally of 7 years, starting as a legal officer, then senior legal officer, and then with a year as acting executive secretary, meaning heading the secretariat of the commission. During this period in Banjul, he also found time, pro bono and voluntarily on a part-time basis, to teach public international law, conflict of laws, and constitutional law at the Department of Law at the University of the Gambia. He had, in his previous career before joining the Intergovernmental Service, been a lecturer in law at the University of Buea in his native Cameroon. He holds a Bachelor of Laws degree from the University of Yaoundé II in Soa, Cameroon, a postgraduate diploma in human rights law from the University of Zambia, a master's in law from the University of South Africa, and a PhD, a doctor of philosophy in law from the University of the Witwatersrand. So welcome very much to our panel, Dr. Eno.
Thank you, Don, and good afternoon, good morning, good evening, wherever you are, to the distinguished participants. Unfortunately, due to the connectivity, I didn't properly follow the presentation by the last speaker, the judge. I hope that I'll have the opportunity to get it distributed. Don, let me start by thanking you for inviting the court to share its experiences on this very important topic, mainstreaming gender in international courts and tribunals on the continent. I'll follow the pattern I will facilitate presentation. So if you don't mind, I will respond directly to those questions. I think that will be easier for us to follow. But let me preface my presentation by saying most of what I'm going to say in terms of gender mainstreaming will be based on the African Union policy on gender parity and gender mainstreaming, which has been going on for quite some time now. What the court has done is actually to implement those AU policies and translate them into the work of the court. We may have gone a bit further, but we have all been inspired by what happened at the African Union, being an African Union organ. The first question I was asked to address is how can regional courts and tribunals redress gender inequalities and foster gender mainstreaming in African international courts and tribunals? I started by looking at some of those inequalities that are gender-based and identify a few, including unequal access to education, lack of employment opportunities, job segregation, lack of adequate legal protection, lack of adequate access to justice, poor medical care, lack of religious freedom, and the lack of political representation. Those are some of the inequalities that can easily be identified from the gender line and which in most cases affect the female gender. How can regional courts redress this? A number of proposals, including the fact that we can promote sensitization programs to sensitize policymakers on these inequalities. We can encourage those who recruit to be more sensitive and recruit more underrepresented gender. We can also facilitate the election of more judges from underrepresented gender and publicize judgments and decisions of international courts, especially those judgments relating to gender issues. Again, we can organize targeted training and courses on litigation for gender-related matters before international tribunals. And one other thing which can be done, which is a bit difficult, is to facilitate employment for spouses who get employed in international tribunals. I understand at the defunct ICTR, the International Criminal Tribunal for Rwanda, spouses of those who were employed were also given some opportunity to work at the tribunal so that they can make their make themselves more productive. Unfortunately, at the AU, we don't have that opportunity to employ spouses just by virtue of the fact that they have accompanied their spouses to join the African Union. The second question I was asked is what are the inequalities in terms of positions held by women elected, appointed, or employed by the African Court? To respond to this question, I will give you some statistics. we all know that when it comes to gender parity with respect to judicial bodies on the continent, the African court is number one. Of the 11 judges, there are 5 female judges and 4 male judges. But the situation with respect to employment of staff is not very good. Currently, the court has 72 staff members employed in its employ. 20 of them are female, 52 are male. At the professional category, there are 38 professional staff, only 8 are female and 30 are male. At the divisional level, we have 2 divisions. Here, all the 2 divisions are headed by females. And at the unit level, we have 16 units. 14 are headed by male and 2 by female. And the general service staff, as I indicated, we have a very poor record, only 52 males and 20 females out of 72. In this regard, recruitment, the court is performing very poorly. In a later stage, I'm going to indicate what the court is doing to improve the situation. The third question is from a comparative jurisdiction, what measures can be employed to ensure gender representation amongst judges and staff? I have identified a number of measures that can be taken. And the first one is to adopt strict criteria that should be included in the enabling legislation or statute establishing the court or tribunal. At the African court, the protocol of the court, Article 12.2, indicates that due consideration shall be given to adequate gender representation in the nomination of judges. Unfortunately, this particular provision was not followed in the early years of the court. There was no proper mechanism in place to ensure this, and that is why in the first election in 2006, there were only 2 female judges, and that number remained like that right up to 2016. In 2016, however, the African Union took a bold and decisive step to address the situation. It adopted a decision entitled "The Modalities on Implementation of Criteria for Equitable Geographical and Gender Representation in the African Union Organs." And with your permission, I'll read the relevant part of that decision. The decision indicated that the regional representation, where applicable, shall be that 2 per region, and there will be 1 floating seat. And at least 1 member, and this is the important part of it, at least 1 member from each region shall be a woman, and the modality shall become effective immediately. So the decision was adopted and was implemented immediately. And the African Union Commission was requested to ensure the scrupulous implementation of this decision. This, in my view, was a turning point and has been, and the decision has been implemented scrupulously by the African Union Commission. So in July 2016, during the election of judges, the African Union refused to conduct elections for North Africa and Southern Africa because these 2 regions had fielded only male candidates. So the election that ensued saw the election of 2 more judges, and in July 2018, 2 more judges were elected to the bench, making it 6 female judges and 5 male judges. So in my view, this goes to show that where there is a political will to enhance female representation, enhance gender mainstreaming, there is a way to do that. So the AU demonstrated political will, and that is why we are reaping the benefit of that. For staff, we have taken a number of measures to enhance gender mainstreaming. The new rules of the court adopted on September 25, 2020 is written with a gender-sensitive lens. Rule 10.2 of those rules provides that in the composition of the bureau of the court, that is the president and the vice president, the principles of gender parity shall, as far as possible, be observed. So if the president is a male, as far as possible, the vice president must be a female. This is now inscribed in our rules. With respect to staff, Rule 16.2, dealing with the composition of the registry, provides that in the composition of the registry, gender parity shall be observed. And in the appointment of the registrar and deputy registrar, the court shall, as far as possible, consider gender and language. So again here, we look at not only the registry as a whole, but we also looked at the senior management, the position of registrar and deputy registrar. If the registrar is male, as far as possible, the deputy registrar has to be female. So there again, we are trying to see how to enhance female representation and the gender mainstreaming. The fourth question was, what are the issues that affect women as staff of the court, court users, actors in the legal field, or victims? And what are the measures being taken or that could be taken to address them? I've identified a number of issues that may affect women, including sexual harassment, the question of confidentiality. There are some female complainants who come to the court and want to speak only to female staff members. So we make arrangements for them to see female staff members. Another issue could be the means to access the court. Most would-be applicants may not have the means to access the court. Another challenge may be knowledge of proceedings or how to litigate before the African court. The measures that we put in, we have tried to reduce the number of short-term positions as much as possible. There was a commission of inquiry within the African Union that found that there was a lot of sexual harassment within the African Union and targeted mainly towards short-term staff because their conditions were vulnerable. So at the African court, we have tried as much as possible to convert almost all the short-term positions to regular positions so that short-term staff cannot be victimized because of the nature of their employment. The second measure we've put in place is to implement a legal aid program to facilitate access to the court. As I indicated, we have made provision to provide female complainants, female staff members to deal with cases where female complainants insist on seeing female staff members. We have been conducting regular training for counsel to be on the court roster. So far, we have about 119 that we have trained. Unfortunately, the number of females are a bit low. Out of the 119, we have only 26 female and 93 male. But we also have pro bono counsel, 4 female, 4 male. To date, however, we have more than 10 female advocates that have appeared before the African court to represent parties, either appearing in person or on paper. The majority have come from Tanzania, the large majority of them being female. We also have female lawyers from Burkina Faso and Kenya. We've also had female witnesses and experts, as well as Amici. The last question, Don, was can you share best practices on gender mainstreaming? As I indicated in the election of judges, we have the AU decision, and we can say the political will to implement that decision is what has resulted in gender parity. And the recruitment of staff, I've indicated that our new rules provide for serious gender considerations in the recruitment of staff. We've gone even further in the new building that we are about to construct for the court. We have consulted the female judges to give specifications on how they would like or what they would like to be in the female chambers. So they have been duly consulted in that regard. With respect to furniture, we've also duly consulted female judges with respect to their sitting posture, where to put their bags and other items, so that they are as comfortable as they can be. With respect to the robes, we also consult female judges on the design of the robes, how the bibs should be shaped, the texture of the material, the length of the robe, and whether they would require pockets to be put in those robes or not. So very briefly done, this is what the African court, inspired by the policy of the African Union, has done to mainstream gender in not only elected positions, but also as far as the recruitment and the well-being of staff is concerned. I thank you very much.
Thank you very much, Robert, for that. Again, there's a lot that you've said there, so I will not try and unpack it now, but actually encourage the participants, our members and our friends on the call, to be unpacking this as we go along, using the chat box, using the question and answer box, and so on. And to save us time to do that, I'll move immediately to our third panelist for this session. And that's Dr. Renifer Madenga. Dr. Madenga is a gender and humanitarian specialist. She is currently executive director of Juniper Consultancy, which is a pool of experts working in the area of gender and the international criminal justice system. She's a registered legal practitioner with over 30 years of experience in human rights and humanitarian issues, from national levels to regional to international levels. She also has a wide range of experience in international legal advocacy, in gender mainstreaming, and in capacity building. Among other things, she has served as a gender advisor and an investigator of sexual and gender-based violence and crimes with many United Nations agencies and with many other non-UN agencies, including NGOs. She has also served, and I believe is still serving, as the humanitarian expert on the panel of experts on South Sudan appointed by and reporting to the United Nations Security Council. She's also served as an international legal consultant and gender consultant for Justice Rapid Response, JRR, which is a very boutique and unique platform that brings together many experts that work in the area of international crimes, doing capacity building, doing investigations, forensic investigations, and so on. And with JRR, she has undertaken many assignments, including missions to Libya, Nigeria, Uganda, South Sudan, among others. Renifer has also worked for the UN International Criminal Tribunal for Rwanda, UNICTR, which is where we first interacted with her as PALU and as the East African Law Society, where she was many things: case manager, trial attorney, senior trial attorney, legal advisor. Before her international career, she headed a women's rights NGO, Musasa Project, but had also been a regional magistrate and a public prosecutor in her native Zimbabwe. Her doctorate and a master's degrees focus on conflict-related sexual violence and on the international criminal justice system. Without saying much and apologizing that I don't have the flair of my friend and treasurer, Gigi, welcome, Renifer. I think you're still on mute, Renifer.
Sorry for that. Can you hear me now?
Yes, we can.
Okay, thank you.
Yes, we can.
Thank you, Chair, for that introductory remarks. I just indicated that it's a privilege and an honor to share the panel space with the Honorable Judge and also the Honorable Registrar. And I also wanted to start by thanking the two sessions yesterday, because they actually put a very formidable foundation in terms of gender mainstreaming. So much so that I don't have to go into some of the basics. So I thought as a point of departure today, I would really like to indicate upfront that the issue of gender politics is very controversial. So I'll be flagging some of the controversies which I think we need to dialogue on that, because for a long time we've not talked about it. And sometimes we are where we are because we didn't have a very transparent, honest dialogue about where we are coming from, where we are, and where we want to go. Controversial as it is, I should also celebrate the gains which has happened, even in terms of what we've seen with the African Court on Human Rights and People's Rights, the gender parity in terms of the appointment of female judges, and also even where we are still trying to make sure that there is gender equality and gender balance, we also have honorable judges who are sitting at very high positions, and these are qualified people, and also they have a lot of experience. So what I just want to focus today in terms of the content map is, if we look at where we are coming from and where we are and where we want to go, the gender inequalities which still exist, in terms of gender mainstreaming, what is still outstanding and what should be done. So I think the audience is mainly lawyers, so you know the open questions we asked during cross-examination. What are we focusing on? Why, how, where, and the like. So I thought in terms of it being very interactive, I would actually want to highlight some of the issues which I think we should focus on. From a historical point of view, the legal profession, the legal framework has always been a privilege for very limited people. I think you can actually know that even from Nuremberg, it was not a case of the complainant, the survivor against the perpetrators. It was mainly about states. So I was actually looking in terms of our regional courts, that we have national courts, we have regional courts, and also international courts. We also have international tribunals. So I think the regional courts are strategically placed in terms of imposing the rule of law. Because when we talk of gender, yesterday it was made very clear that it's about men and women. It's about girls and boys. So it's all inclusive in terms of, we are also talking of generations, the young, the old. We are also talking of gender, the men, women, boys and girls. We are also talking geographical in terms of diversity. We are also talking of other things in terms of different sexual orientation. We are also talking about different political ideas. So we are coming with, we are very different, but how do we move on in terms of achieving gender equality? And in a world where we have almost over 50% of a certain gender, then in terms of positions and equality, you will actually find that most of the times there's a certain gender which is marginalized. But in terms of moving together, because we can only achieve even the millennium goals if we actually move together. So when we look at, we are now celebrating what is happening, but for decades and decades, women have not been involved in different capacities. If you look, for example, what I talked about, the Nuremberg, it was only when the Tokyo tribunal came, when women started now talking about they've been used as sexual slaves. So it's the development itself which brought us to the table now where we talk of gender. Is also a problem which, when we contextualize it in Africa, there are now multi-layers. We are not only talking about the legal frameworks, we are also talking about other embedded imbalances, like the issue of patriarchy. So it's no longer just about the balance in gender. It's also coming with the whole cultural baggage. So much so that if you go on a road of, we take like what the honorable judge was saying, when someone is a judge and when someone has been properly appointed, the first question is, are they qualified? But in the docket of Africa, you find most of the judges, whether at national level, regional level, international level, they are actually overqualified in terms of academic qualifications. And they are also equally overqualified in terms of experience. We have like countries coming from armed conflict, countries like South Sudan, Sierra Leone, Rwanda. You find some of the judicial personnel, whether they are defense counsels, whether they are actually prosecutors, whether they are judges, they've actually a lived reality of what is armed conflict, what is lack of rule of law, and how does the lack of rule of law actually rule out other categories of people, especially women. So it's from that post that I want to say, in our regional courts, how do we address and how do we redress gender inequalities? And how do we then foster mainstreaming of gender, especially in these tribunals? The Honorable Registrar and also the Honorable Judge have already indicated some of the gender inequalities. For example, when it comes to accessing the courts, we are also talking about other players, lawyers, and also the survivors. So even in terms of gender justice, because I'll focus on gender justice, you actually find that some of the gender equalities go to barriers. Why do we have people, so many ordinary people, not accessing justice? Maybe even in terms of the geographical location of the tribunals. The Honorable Judge and the Registrar talked in terms of when you are part of the staff, or whether a judge or you are employed, some of the challenges which comes with relocation. So we are also looking now, if I am a court user, maybe I am a witness, what are some of the challenges? So, and how can those challenges be addressed? That is why we say, if we agree that there are gender inequalities, then we should also agree that there should be gender mainstreaming. Then the question will say that as AU, there are already established protocols, even enshrined in the charters, what we should do. But my question today is the dichotomy between rhetoric and reality. We have a very good gender profile, gender directorate, gender issues in terms of the Maputo protocols. But then when we come to the ground, the lived reality of someone trying to access those courts, maybe not only as a survivor, not only as a witness, but also even if you are trying to defend those people. And then it comes also to the mandates which go with the regional courts, that they are dealing also with human rights issues, issues of democracy, issues of rule of law, the states. Then if we start even to interrogate some of our states, even in Africa, you will actually find that there are so many other things which actually makes gender mainstreaming not effective, in the sense that starting at national level, you find that there are so many gender inequalities. There are so many violations, so much so that by the time we come to the regional court, we talk of resources, we talk of not only geographical barriers to the courts, we also talk in terms of psychological barriers, because given the status of women, especially in Africa, and it's not only in Africa, generally, the status of women and girls, the status even of men. So when we talk now in terms of gender, we are talking of both men and women, but we are saying that they should also be a target intervention, where you actually say, given the status of women globally, when we come to act locally and we want to mainstream gender, what are some of the strategic approaches which we can actually employ in order to achieve gender equality? So how can we recognize and respond to some of the gender norms, which gender norms are actually bottlenecking gender mainstreaming? I think in terms of the definition, I know I don't want to bore professionals with the definition, but I think it's also very important that we know that the definition we are using has already been confirmed and incorporated in so many AU protocols, provisions, and also it's the same one which was developed in the UN Economic Social Council alleged conclusions. Allow me to read it because it will set out the way we want to move forward. When we take a strategy of gender mainstreaming as a process of assessing the implications of women and men of any planned action, legislation, policies, programs in all areas and all levels. I want to underscore and emphasize that we are doing things at all levels and all areas. If we take it as a strategy of making women as well as men concerns and experiences an integral dimension of design, implementation, monitoring, evaluation, the ultimate goal is to achieve gender equality. But the bottlenecking is at marginalizing certain people, certain categories of people. I want to move forward from there and look squarely at the issue of including people in the processes of the courts. Most of the time, there is no local ownership to ensure that both a human rights approach is taken and also a gender sensitive approach is taken in order to deal with the barriers. Not only the physical barriers, there are also institutional barriers, normative institutional barriers, like as much as judges can be appointed, lawyers can actually act, there are nuances which actually make the legal fraternity a very controversial area in terms of operating efficiently. There is a lot of stigmatization. For example, it has already been indicated that in other areas, there is a lot of disparity in even the numbers. But even if we go beyond the numbers, the way people interrogate, even where female judges have been appointed, it's like, why has she been appointed? Is she related to anyone in political leadership? Or so people question that because it's like in a patriarchal society, people actually think that women should be relegated to certain societal roles. If they are very young, they are supposed to reproduce. So what are they looking for at the bench? If they are not young but middle-aged, this is the time they should be looking after certain socially constructed roles which have been allocated to them. When they are old, maybe this is time these women should be doing other things, looking after grandchildren. But when it comes to the other gender, if a person is young and appointed, people are very happy that, oh, this is a high flyer. So even the words we use, when the person is middle-aged, it's like they are building a career. But most of the nuances are that whatever happens to women, even women as judges, is constructed like they are rebelling against certain certain norms in society. It's like it's a rebellion. What are they doing? Why are they leaving Uganda to go to Arusha? So there are so many connotations related just to being a woman in power. Then if the person then happens to be like a lawyer, there are also certain expectations, even dressing. I remember sitting on the bench the other time that the discussion was about how lawyers are dressed, but it never really touched on men. Even their hairstyles, people who come dressed in whatever way they want, but it was mainly the female part of the legal fraternity where there were so many questions. The same applies also to the question of witnesses. When they are witnesses, most probably depending on the composition of the bench, you actually find that when people come as male witnesses, as experts, the kind of respect they command and are given can actually differ. Sometimes when you then have a bench which is already trained in gender sensitive language, in inclusive language, gender responsiveness, you actually find that it actually helps to give legitimacy of that bench, which takes us now into the other inequalities, which also comes with their positions. It's like, generally speaking, there is also feminization of a certain gender. So you find even people who actually take the position, some of them might not take the positions because of issues, not necessarily relating to their career development, but relating to other economic, social, and political issues. So you actually find that when we talk of mainstreaming gender, we are looking at all the dynamics, the power dynamics which goes with it, the gender justice, accountability, the protection of the rights, the other gender expressions which are often related to gender work and the gender inequalities. I also want to move and talk at the importance of gender balance, the perceptions, the different approaches. I remember that during the course of the International Criminal Tribunal of Rwanda, the bench was composed mainly of male judges. But where there was like one judge, like one case, the Akayeso, which people normally say is the first, it was the female judge who actually discerned from the evidence of all the witnesses that although the accused was not charged with rape, everyone was talking about rape. So the reason why people underscore the fact that there should be a gender balance is people look at facts, at the law, and then interpret it also using their lived experiences. And you find that the majority of people who have experienced or who have reason to have experienced some of the things will bring a very rich contribution to the bench. So I think we are past why should we have a gender balance? We are almost past that. But now in the case of COVID, I was actually saying it's bringing home the fact that when we say that we want to mainstream gender, we want an inclusive strategy, we want women, as many women at also leadership areas, we are also talking of, if we are going to move forward, then we want everyone to contribute. We want everyone to actually make an impact, because there is nothing for us without us. So who is the us? It's like women as staff, women as judges, women as lawyers, men coming also. Yesterday we talked about men championing gender sensitive processes. So you'll find that it's a whole partnership. And then the fact that people now have come to realize that if we are going to move on, then we need all the genders. We need women who are also court users, the complainants, the witnesses, actors in the legal field, all actually coming together and say, we are now in a critical role. How do we prepare to move in an equitable recovery place within the legal fraternity? And also between these interventions, we are also saying that they are now we don't have enough successful long-standing examples of successful gender mainstreaming issues. But then with the COVID thing, we are actually realizing that most of the good practices are also shaped by policies, which also include both genders. So if we are at managerial level, at leadership level, if we have both men and women who actually know what it is also to make policies within the pandemic, you'll find that it will actually accommodate so much in terms of how people move forward. So I was actually saying in most cases, most institutions, we look from the culture and people are just talking about adding a component of women. If we don't have enough women at a certain level, then they just add. But then mainstreaming gender is not just adding a component. It's actually going into the issues, starting from the planning, the situational analysis. It has to be very context specific. What do you want to achieve? We have to have a background of the overall intervention. What are we focusing on? If we say we are focusing on women as witnesses, what are their concerns? What are their needs? What are their aspirations? Is there an extensive consultative process which brings them to also contribute so that there is local ownership? They identify with whatever we want them to do. Also, there is an agreed strategy. How are we going to implement that? And also there is a proper budget. If we are going to do something for a certain category of people, even witnesses or survivors, they are not a homogeneous group. So each one, they come with their own different concerns. How can we incorporate those concerns? How can we have learned processes which are informed by their needs, by their concerns, and by their aspirations? I think I'll end there. And if there are any questions, Mr. Chair, I would love that you read it out to me, because I noted on this computer I'm using that there is a technical problem. I'm not seeing the questions.
Okay, I will do that. If there's any that's directed specifically to you that requires answering, I'll do that. Otherwise, we'll also just give you a chance again as panelists to kind of respond to many of the issues that have come up. Ladies and gentlemen, thank you very much for your patience till this minute. And I keep on urging you, I've seen some beginnings of a robust debate in the chat and of the Q&A, because we are over 150 people at the moment in the conference. We might not get to hear everybody's voice. So please use the chat liberally. And before we, open up to full interactive, I'd like to honor our partnership with SADC Lawyers, the Southern African Development Community Lawyers Association, by also allowing them and inviting them to have a voice and give us a perspective of how they're approaching this thing as a regional lawyers association, as opposed to how we're approaching it as a continental lawyers association, although we work very keenly together. So I will invite Ms. Rehana Khan Parker, advocate, our colleague, to just come in and give us the voice of SADC Law.
Thank you. Good afternoon, and thank you to PALU and to SADC Lawyers Association for giving me this opportunity. Speaking to you, everyone from Cape Town, South Africa, and of course, I need to just sketch the framework within South Africa. South Africa, obviously, as you all know, prides itself of upholding the rule of law. That is what its cardinal feature is, that you have the separation of powers, legislative, the executive, and the judiciary. And within our government has ensured that from a legislative and an executive point of view, that there is equal representation for women. So within a cabinet, from a cabinet point of view, government has achieved its objectives by having a parity of 50-50%, as well as it has dedicated an entire department, an entire ministry for women, youth, and people with disabilities. Within the Bill of Rights and our Constitution, we have institutions such as the Commission for Gender Equality, which is an institution to promote and protect those who are treated unfairly in terms of gender. Besides that, we have two other pieces of very valuable tools, and that is the Black Economic Empowerment Code, which is the transformation code to ensure that post-democracy 1994 to today, we ensure that we get the affirmative people in place to ensure that they get the positions, as well as the Employment Equity Act. So each company, private or public, needs to ensure that it complies with the employment equity codes in terms of gender and, of course, race, as well as our Legal Practice Council. So we have a Legal Practice Council, which is a new council, as you know, as many would know. And they have just recently, as late as last year, introduced the sexual harassment policy for law professionals, because unfortunately, within the law profession, sexual harassment is very rife, especially in relation to the unequal powers, the inability for young candidates who are just emerging from university to get positions. So there is that unfortunate room for sexual harassment. So that's certainly been very welcomed. In terms of our judiciary, the high courts have not quite got there yet, probably sitting at about 35 to 37% in terms of gender balance. Our lower courts, that's our magistrates' courts, where most of access to justice, takes place in terms of domestic violence, family law, and interdicts and sexual offences, they have successfully reached more than 50% in terms of gender parity. However, whilst there is a political will, the difficulty sits that women who are now, in fact, in South Africa, and I'm sure in the SADC region as well, emerging from universities, the figures and the statistics tells us that there are more women graduates, but where are they when you look around in the private sector? And that happened at the BRICS conference. It was a BRICS conference held in South Africa 2 years ago, and I was one of very few women in that room. And that gave me the idea to create an awards program, because the complaint was that there are not enough women in specialized areas. And that's where I started an awards program to recognize the trailblazers, change makers, and tell the private sector, who does not have the political will, to change their telescope and their lens and open up opportunities. With that, and that is where I'm coming to gender mainstreaming, and within Africa particularly, was that gave birth to an academy. We had realized that there was still a lot of training that needed to be done. And we then worked with South African women judges making a difference. We judges said, we are here to hold your hand, women in the profession, we will assist you in ensuring that you get upskilled in specific areas. We're talking tax laws, marine law, mining, very areas which are largely dominated by our male counterparts. We successfully ran that over a period of 1 month. We had 10 training programs. As we know, COVID doubly affected women in the profession. And unfortunately, in South Africa, there was not a gender lens for women to access funding from our Solidarity Fund, which was the relief that was afforded for people who had suffered financially. There was no gender lens attached to that. That then gave us the idea that something more needs to be done. We've watched this space very carefully before the lockdown. We watched the skewed briefing patterns. We kept on saying, where are the women? Why are women not being briefed by the state? And we started examining exactly the trends that happens within government, because it needs to filter down from the executive to the legislature to actual departments. So that is one thing that we had done. But one aspect which definitely stood out for us was the Law Society of England and Wales, called the Law Society, had conducted roundtables throughout the world. South Africa responded. My organization, which is Women Lawyers, the Women Lawyers Academy, was a Women Lawyers Academy, was part of the respondents. We were part of 8,000 respondents. What that taught us was it gave us a round table in the form of understanding gender stereotyping. We needed to take it down to understanding why is it that we are still sitting with this generational culture of violence? Why is it necessary for our Legal Practice Council to give lawyers a sexual harassment policy? So that tool of the roundtable was exceptionally important. It dealt with key issues: discrimination in the workplace, diversity, very important. It was a hot topic in South Africa in 2020, inclusivity, as well as the gender pay gap. Of course, COVID-19 took care of the fixed working hours because we're all working remotely. And it was shown that courts in South Africa, which remained open during the pandemic and still remains open as access to justice, we were able to conduct our trials via Zoom successfully. So there is a different way that we can do it. What then came out of the roundtables, conferences, and President Ramaphosa's speech in June 2020, he said, we need to break this generational culture of violence. By looking the other way, we become complicit. That is where we, as WASA Women Leadership Academy, decided to take one step back. We said something more needs to be done. So what is it that we can do to change this generational culture of violence? Of course, it's not peculiar to South Africa. It touches the world. If I can just use Caster Semenya as a case, she's a woman, but people perceive her as a male. Now, she looks perfectly fine to us. To us, she looks like a normal African woman. It's again got to do with the embedded discrimination that sits within people. So we've devised a program, 2 programs. The WASA Women in Law Awards, which was supposed to take place in 2020, became a COVID Warrior Awards. 2021, we're going to be introducing the first male champions of change, because we do need males in this discussion. We cannot take this forward. We cannot talk about parity on the bench, parity in terms of the workplace and boardrooms and getting seats at the table if we do not understand and take it back to basics. So we've devised the program, and the program is based on what I heard from the university in Washington. Each staff member at university there, every 3 years, must undergo gender sensitization. And that's the only way I believe that we are going to be introducing it. Of course, South Africa is very unique. Africa is very unique. We have issues of our own, different to the rest of the world. It's been raised in this panel discussion. The issue of religion, very different, and the issue of culture. And therefore, we need to find a fit that suits us. We cannot fit into a European thinking of gender sensitization. Ours must be framed differently. So we are busy engaging with various universities throughout the world, where we would be engaging with a program it would be in certificate form for now. We have several universities in South Africa, and I'm sure in Africa, that offers gender studies from undergraduate to postgraduate level. We are saying we need to respond to the pandemic and this gender-based violence pandemic that we are confronted with. How can we do it effectively? If we can get our workplace to emulate the university in America by ensuring that each new employee that comes into the workplace undergoes such training. We all know it in our businesses, in our firms, and in big private businesses. Nobody has the time to sit with an employee to train them on their sexual harassment policies within HR. Nobody has the time to sit and teach them the do's and don'ts, because we all come from different cultural, unconscious biases, and we need to unlearn it. And the good thing is we can unlearn unconscious bias. How do we do it? Can only be done through education. Let's get the awareness and the training through education as a certificate course, make it available to as many people as possible, with the hope that South Africa, SADC region, and the African Union region will follow suit the model that Washington, in fact, it's Howard University in Washington, D.C. Has done. So our response, I would think, should be on targeted training, how to undo the embedded discrimination, how to unlearn it. We need to formulate strategic partnerships within Africa. We need to ensure that we become a global sisterhood, a global brotherhood with a strong African voice. So that if positions, for example, the position on the International Criminal Court becomes available, that we ensure that we as a collective, and if it's a woman standing, that we all stand behind her and we support her. So I think I've said enough so far as upholding gender mainstreaming. I've left you with an overview of the difference that Africa has to the rest of the world, is that we have the cultural nuances, and we have the patriarchal nuances, which are quite different to the rest of the world. I thank you for this opportunity, and I look forward to creating further relationships. And I hope to see many nominations come through, especially for that male champions of change. We need you men. We need you to speak to other men, and we need our women to ensure that we empower other women. Thank you so much.
Thank you very much, Ms. Parker. And again, Ms. Gigi Reed-Miles, our treasurer, has reminded me to please reiterate her apology that at the last minute, her internet let her down, and she was not available to, steer this session and participate in it as she would have liked to. As I mentioned yesterday at PALU, we started a Women Lawyers Forum way back in 2016, and both Ms. Miles and later our Vice President for Northern Africa, Ms. Fatia Hedeli, Ms. who's on the call, have been quite active in it, trying to lead from the front. So that is a Women Lawyers Forum. That is not to say that we have started yet, and maybe that should be the challenge, a Gender Equality Champions Forum within PALU that will have both women and men working together for these objectives. So maybe those are the things that are open to discussion now. I can see that time has run out a bit, and I do appreciate very much the input that has come from SADC lawyers, from Ms. Parker, with an innovation that we can emulate. I was going to say two things. One, the chat has been quite lively, and I've seen that Justice Mugenyi especially has been engaging those that engage her with questions, with ideas, with suggestions on the chat. There's no direct question yet to you, Ranifa, but there might be some general points, and I'd like to bring one to attention. So time being of the essence before the next session, I had one question each for Judge Mugenyi and Registrar Dr. Eno, and one for Ranifa. And the question that I had for Justice Mugenyi is the same one I asked for Eno, and that's on the question of disparities. we are seeing quite some remarkable disparities in the trends that the two of you gave us with respect to these two courts, the African court and the East African court. At the African court, at judge level, they have almost achieved gender parity, almost 50-50. 5 female judges to 6 male judges. At the East African Court of Justice, we've never come close, not in the first iteration of the court, when it was a single division, a single bench of 6. We had 1 woman and 5 male judges, not in the current iteration of the court, when it is 2 benches, an appellate division and a first instance division. The highest we've ever achieved, I think at any one point in time, is 2 out of 11. Yet at staff level, it's the inverse. The African court that has achieved 50-50 almost at judge level is doing 20 female to 52 male members of staff. Whereas the heads of the division at the moment, the 2 divisions in the registry both happen to be female. At professional staff level is doing 8 women to 38 men. Yet at the East African Court of Justice level, they've almost achieved 50-50, both at professional staff and at support staff level. So what do you think accounts for these disparities? And what could we do to avert them? What is it within the role of the electors who are heads of state outside there? And what is it within the power of the court to do for itself? And a second question that I'd ask to each of you too, on the issue of sexual harassment. And we've talked of the innovations that you have been able to bring in these 2 courts in terms of the rules of courts and its policies. Do you think that these courts are ready to have an explicit sexual harassment policy adopted by the courts that we have right now? And if not, what can we do to get there? So those would be my questions for you. And for Ranifa, we focus a lot, and I like that you open the debate to ask the Judge Mugeni to the various players of the court users, witnesses, litigants, lawyers, counsel appearing before the court all the way to judge. Again, now taking you a bit out of that, in terms of your long experience with the UN, especially with the Rwanda Tribunal, which tried to do many unique things, including come up with an internal written or unwritten policy of trying to find jobs or things to do for spouses of staff, international staff who move to Arusha. What are the best practices do you think you can distill from especially your ICTR UN stint that we could deploy at our regional courts and tribunals? Thank you, and then I invite Judge Mugeni.
Thank you, Donald. I'll start with the first question, which, if I understood you right, is the East African court is nowhere near parity and has never been in terms of judicial representation. And what can be done about it vis-a-vis the lower staff levels? Let me start with the lower staff levels. I think while 2 things, to begin with, the support staff, professional staff and general staff are appointed on the basis of a quota system that primarily focuses on national representation. We operate a quota such that each country has a set and equal quota within all the states. Once that quota has been exhausted for country X and country Y is still at say half level, country X will not advance any candidates for any position until country Y has quota. This was mainly advanced because the original East African community, part of the reason it collapsed was because there was a sense that the Republic of Kenya was benefiting more from the positions available and other dividends of the community vis-a-vis the other partner states. So to ensure equitable balance in the resources and opportunities available within the East African community, a sort of quota system is operated in staff employments. So in a sense, you could argue that the gender parity realized at that level is more of a coincidence because no specific effort has gone out to address gender issues in that sense. But by coincidence, in the course of addressing national representation, gender representation in the court has got it right. However, my concern personally would be more about the nature of this representation. If you have the men there dominating the decision-making positions, and the ladies are largely secretarial, the few ladies that accessed the professional jobs tend to be at tier 1, grade 1, the professional jobs. But grade 2, 3, 4, 5 are dominated by the men. There is, in real terms, there is not much advancement you're making, because when it comes to taking decisions, the 4 men will sit together and take the decisions that affect the ladies. And that ties in as well with the sexual harassment policy. In my tenure, we only got 1 sexual harassment report. There is no policy that I know of. It was settled quietly between the victim and the perpetrator. I was a member of the executive leadership, but I was never told about this officially. It was kept under the wraps by the male decision makers, and it was resolved at that level. They probably thought if we involve the young female who is at the executive leadership level, she might escalate it. So they preferred to keep it under wraps. I quietly engaged the victim. She told me her story and then said she didn't want it to go further. Whether she had been pushed into a corner in terms of that position, or she was trying to protect other interests, because women sometimes are thinking about, if this gets down to my family, reputational injury, and all sorts of things. Whatever her considerations, she was willing to wrap it up at that level. Now, the female judges, in terms of judicial appointments, the way judicial appointments are done in the East African Court of Justice is a very simple but informal process. Countries simply nominate nominees for appointment by the heads of state. They do not even have to go through the Judicial Service Commission of the national states. Heads of state simply headhunt through the different institutions. I wouldn't even say there is a uniform way it's done by the different heads of state. Each head of state approaches it his way. But what we are trying to do through gender meetings, sort of such as this one, we have tried to raise the level of engagement on that. There was a gender meeting organized by the World Bank, I think, and it had high representation in terms of the chief justices. All the chief justices of the East African countries were represented. And amazingly, the only lady, at that time, I was the only lady judge in the East African Court of Justice, but I was not invited. So 2 male judges were invited together with the chief justices, all of whom were male. So I told myself, since it was in Arusha, I invited myself, got into the hall, got accreditation, got in. And the moment it was time for questions, I said, since all the chief justices are here, it's time to raise the issue of gender representation. Of course, it was not easy because the African court is fairly evenly balanced. But we raised the issue of the East African Court of Justice. And as a result of that, because the Tanzanian Chief Justice was in attendance, we got a nomination for a female judge from Tanzania. So I think we are going to have to simply keep on talking about these issues and hoping, I had somebody talk about networks, hoping that the points using our networks land in the right ears and something is done about it. We don't necessarily have to make so much noise about it, but if we get the right networks and get the right associations to back them up, we will have enough of a voice to get people to listen to the issues that are raised in terms of gender representation. Coming from Uganda, Uganda has always nominated a female and a male to the East African Court. So we've always had a male and female representation, one in appellate division and the second in the lower division. However, there's nothing cast in stone. Anything could change. So I think it is time to have some sort of uniformity in terms of gender representation in appointments all around across the board, and some sort of consensus as to what criteria will be used. Otherwise, if we don't do that, we run the risk of being left to the mercy of the appointing authorities. That's all I think I needed to say about it. Is there anything I've left out?
No, my lady, I don't think there's anything you've left. Thank you very much for that. As you correctly say, we can never finish this conversation and this campaign on one day, and we have to keep on going at it. So I'm going to invite Dr. Robert Eno, but before I do, to ensure that mine is not the only voice heard from this side, I'm going to request our Vice President for Northern Africa, Ms. Patia Hidili Misus, who had requested for the floor, to take the floor now and to ask the question that you had, which was specifically directed to the African Court. Thank you. Vice President Misus, welcome.
Merci beaucoup, Don. Merci. D'abord, j'aimerais bien souhaiter la bienvenue à nos chers invités. Quoique j'aurais aimé aussi voir parmi nous un membre de la Commission de la Cour africaine des droits de l'homme et des peuples. Surtout que la Commission veille au respect de la mise en œuvre de la représentation géographique des genres. N'est-ce pas, Don? Malheureusement, on ne voit pas un membre. Alors, moi, je représente l'Afrique du Nord. Et la question, j'ai d'abord une question et quelques remarques relatives à l'intervention du docteur Enou. Est-ce que vous m'entendez?
Yes, we can.
Alors, ma question concerne la ratification du protocole additionnel à la Convention africaine des droits de l'homme et des peuples qui a été adopté en juillet 2003, auquel Dr Enou n'a pas fait allusion, si je ne me trompe pas. C'est parce que ce protocole qui concerne les droits des femmes en Afrique, il a été ratifié en 2005 et ratifié par 15 pays. Ma question concernant ce protocole, est-ce qu'il a combien de pays actuellement ont ratifié ce protocole? Parce que je n'ai pas les statistiques et Dr Enou, j'imagine, puisqu'il est dans le domaine, puisse nous répondre. Combien de pays ont ratifié? Parce que c'est important de le savoir pour peut-être que je puisse faire les autres remarques. Est-ce qu'il peut me répondre d'abord à cette question?
I'm sorry, Vice President Mesous. We've actually already run out of time and we're eating into the time of the other session. So I'm not sure that Robert will be able to take that question and come back and take another. I'm sorry.
Alors, je passe aux remarques. D'accord. Alors, concernant les remarques, Dr Robert a dit que la Commission de la Cour africaine des droits de l'homme, c'est elle qui veille sur l'application des modalités de représentation géographique. Alors, il parlait aussi des mesures pour garantir les parités au niveau législatif, et c'est l'article 8 de la Convention africaine des droits de l'homme et des peuples, de la charte, excusez-moi, africaine des droits de l'homme et des peuples, qui exige à ce que le principe de parité soit respecté. À mon sens, au niveau pratique, je ne pense pas que ce principe ait été respecté. Et je pense qu'il y a d'autres mesures à prendre en considération. Pourquoi? Je prends l'exemple de l'Afrique du Nord. Dr Enou a dit qu'en 2018, on a interdit aux pays de l'Afrique du Nord de présenter des hommes. Et c'est en ce moment-là que des femmes ont été présentées pour occuper le poste de juge à la Cour africaine des droits de l'homme. Je sais qu'actuellement, pour le nord d'Afrique, il y a le juge de la Tunisie, un juge homme qui est Rafa Ben Achour, et la juge femme de l'Algérie, qui a déjà présenté sa candidature en 2018. Le problème, c'est que au niveau pratique, le principe de parité ne peut pas être respecté s'il n'est pas pris dans son ensemble, c'est-à-dire on doit respecter le nombre des femmes dans toutes les régions et non pas seulement au niveau de l'Afrique du Nord. Pourquoi? Parce que il y a la possibilité pour les juges hommes de renouveler leur candidature. Il est d'ailleurs le cas de Rafa Ben Achour qui a, d'après mes connaissances, il a déposé sa candidature pour renouveler. Alors que le mandat de madame excusez-moi, j'ai oublié le nom, la juge de Mia, je sais qu'il y a une juge de l'Algérie, puisque son mandat prend fin en 2023, si je ne me trompe pas. Alors, il faut donc, dans ces conditions, l'Algérie ne peut pas présenter un homme, elle doit présenter une femme. Et si le juge Rafa Ben Achour continue, donc va être pris parce que la Tunisie actuellement a présenté un seul homme, et c'est lui, d'après mes connaissances. Donc, ce principe ne peut pas être respecté. Il va y avoir un renouvellement de mandat pour les hommes, parce qu'en Tunisie, il y a un homme, et c'est toujours, le renouvellement ne peut se faire que en présentant un homme. Il ne peut pas y avoir…
Thank you very much, and I'm sorry to cut you short. Let's keep it to that question. I'm sure Robert will put it into his answer and tell you about the terms of judges and what is possible. I apologize to my successor, Naro Omosaje, who should have been running the session now. We've run a bit late, Naro. Please, let's just allow a minute each to Dr. Robert Eno and to Dr. Reni Famadenga, then you take over. Dr. Eno, sorry to rush you. Go ahead.
Thank you, Don. Maybe I should explain the way the election of judges is conducted. It is done on a regional basis. Each region has two positions, which comes up to 10 for the 5 regions. And there is one position which is left, which is called a floating seat. That one can go to any region. Currently, and in the election of the judges for each region, there must be 1 male, 1 female. If we take North Africa, for example, we have 1 male from Tunisia, 1 female from Algeria. The term of office of the male from Tunisia came to an end, but because of COVID, I think they couldn't do the election. The elections are going to be done next week. So even if he is not elected from Tunisia, Tunisia will have to, North Africa will have to nominate a male candidate because the term of office for the female candidate is expiring only in 2024. And that is why if you look at the nominations from North Africa, they are all male. You have 1 from Mauritania and 1 from Libya. They are all male because North Africa for now needs a male candidate. There's already a female candidate. Yeah, so
oui, mais ça minimise les chances pour les femmes de la Tunisie de se présenter. C'est ça pourquoi j'ai dit que le principe de parité n'est pas tout à fait respecté d'un point de vue pratique. C'est parce qu'à chaque fois, la Tunisie va présenter un homme et ne veut pas pouvoir présenter une femme. Et autre chose, docteur, l'information n'est pas toujours transmise. La Cour africaine, par exemple, ne fait pas la publicité pour les élections à l'avance. Pourtant, elle nous envoie, moi, pas plus tard qu'aujourd'hui, j'ai reçu l'information concernant la reprise de la 60e session de la Cour. Ça, c'est une bonne chose. Mais par rapport aux élections qui vont permettre vraiment aux femmes de se présenter, de se préparer à l'avance, on ne reçoit pas ces informations. Vous voyez ce que je voulais dire? Donc, la mise en œuvre de la pratique du respect de la parité n'est pas assurée, n'est pas garantie. Si on ne reçoit pas l'information, en temps utile. Si c'est parce que la
Thank you very much for that. Please, let's stop there. Let's stop there because we have seriously run out of time. Let Dr. Robert Eno finish so that we give Renifa a single minute so that we move to the next session.
Okay, thank you, Don. Let me just say that the gender parity within the court, I don't think will change. It will either be 6 female, 5 male, or 6 male, 5 female. It will always be like that, given the AU decision on gender parity. That will not change. But the regions may change the composition as to who gets female or who gets male. That is at the regional level. The second issue that you raised, Don, with respect to disparity for staff, I think we are facing the same challenge like the East African Court. And I think it's the same thing with most international organizations, the issue of quota. This quota is imposed at the highest level, the heads of state level, that each country should have not more than a certain number of staff. And that also affects the gender composition of the institution. And it is not only the issue of quota. When looking at recruitment, we look at gender, we look at the linguistic aspect, we look at the geographic representation, we also look at, for the court, the legal tradition of that particular candidate. So there are a number of things that come into play and which may go a long way to affect whether somebody is selected on what gender. So, but there is no a deliberate policy to minimize any particular gender. We have even taken steps to ensure that at the shortlisting level, we make sure we shortlist at least one woman. If we are to shortlist 5 candidates and all the first 5 are males, we go down and ensure that we get at least 2 ladies to add to that number to make sure we shortlist. Instead of 5, we shortlist 7. So that at least at the shortlisting stage, we have female candidates that can come forward for to sit for the exams. We have also made sure that we disseminate the advertisement as widely as possible. We send them to the embassies. We request our judges to assist us. We send them to NGOs. I think PALU has been receiving our advertisement, so that this advertisement can be disseminated as widely as possible to ensure that all candidates, including female candidates, have the opportunity to apply. With respect to sexual harassment, just to indicate that the African Union has adopted a sexual harassment policy, which is applicable to all African Union bodies, including the African Court. I thank you.
Thank you very much, Robert. I'm really, really sorry to rush you. Renifa, in 1 minute, please, just give us one highlight, and then we move on to the next panel.
In terms of policies, I should say it was like a pioneering work. Policies were being formulated relating to different sections. For example, within the office of the prosecutor, they are learned lessons, but in view of time, I don't have time to list them, but we really had learned lessons. We also questioned the issue of bring families. Arusha, basically, in relation to International Criminal Tribunal for Rwanda, was a family station, which also helped in terms of those families which could relocate to Arusha, depending on where you are coming from. But I just want to point out briefly that in terms of the gender inequalities, in terms of other issues like sexual harassment, it was still a challenge. And also the way we addressed that, it's like, although there were policies, it's like some of the policies were challenges in implementing them. I think this is an area which really needs a lot of time so that we spell out the learned lessons, but in view of the time, I think that should suffice.
Thank you very much for your kindness, Dr. Madenga. Without further ado, we might have summaries at the end, but I would now like to invite my colleague and friend, Naro Omosaje, who's moderating the next session, which is on tech in the legal profession and CLE. Welcome, Naro.
Thank you, Don. Thank you, everyone. That was a great session. Without wasting much time, I'd just like to welcome everyone to the session, Legal Tech and Continuing Legal Education in Africa. My name is Naro Omosaige. I'm from Nigeria. I'm a lawyer and a legal tech innovator. I'm currently the managing director of Lotrella, and I'm also the head of the digital law and policy practice at A&E Law Partnership, a law firm in Nigeria. If you've heard about Lotrella before, if you've been to our site, you have a good idea of what it's all about. But quickly, Lotrella is a platform that enables continuous professional development, networking, and co-working for lawyers. We have an e-learning platform that's designed to help lawyers and other professionals easily access the knowledge and skills that they need to specialize in traditional and new areas of law practice. So we have different courses on law and technology, cybersecurity, blockchain, grant writing, and much more. And as Don mentioned earlier, PALU has gotten a special discount on our legal tech specialization for everyone who is registered for the conference. So from the end of this session, you can log on to www.lotrella.com and sign up for these courses for free. So thank you, PALU. So I'm going to talk more about Lotrella and how we're using technology to build a knowledge sharing community for lawyers across Africa, and how and why we're doing that. But first, let's talk about continuing legal education in Africa and all the reasons why it's important. I'm not alone on this panel, definitely. I'm joined here by some amazing people whose company I am honored to be in. So I'll go right ahead and introduce our panelists and give each of them 5 minutes to make quick opening remarks before we go into the discussion proper. I'd first like to extend the apologies of one of our panelists, Mr. Chibuzo Ikweku, who is also the board chairman of Lotrella. He would have loved to be here today, but unfortunately he had to miss this for work reasons. He sent his apologies. So I have the privilege of introducing an academic, Professor Ernest Ojukwu, SAN. Professor Ojukwu is a professor of law and a senior advocate of Nigeria with over 35 years of teaching experience. He is a pioneer in legal education reform. He's credited with setting up the Nigerian Bar Association Institute of Continuing Legal Education. He's also credited with the establishment of over 12 law clinics across universities in Nigeria. Professor Ojukwu has served as an academic leader in many roles, including as Deputy Director General of the Nigerian Law School. He is currently the President Network of University Legal Aid Institutions. He is he's an author of several books on legal education. In fact, Professor Ojukwu is fondly called the teacher of teachers, and it's very wonderful to have him here. So welcome, sir. Thank you for being here with us today.
Sorry, I think there's a problem with the Hi. Yes.
Okay, so while we wait for that to get sorted out, I will just go right ahead and introduce you, Linda, because you're here. Okay. So one of our panelists is here, Linda Bonio. Do I say she needs no introduction? But I'll go ahead and introduce her anyways. She is the founder and CEO of the Lawyers Hub. It's a Pan-African community of lawyers across Africa who are using technology and policy tools to help support startups and foster cross-disciplinary collaboration across Africa. She's an advocate of the High Court of Kenya, so she's first and foremost a lawyer, but also a legal tech innovator. She's a 2020 Tech Women Emerging Leaders Fellow and the winner of the 2020 Good ID Global Awards on privacy and digital identity. We have Linda and her amazing team to thank for working with PALU behind the scenes to bring this wonderful conference to us. So thank you, Linda. If you want to find out more about the Lawyers Hub, you can catch them on lawyershub.org. Thank you so much for being here, Linda. 5 minutes, please.
Thank you very much. Do I go ahead?
Yes, yes, please.
Oh, okay, thank you very much. And thanks for the kind introduction. I really appreciate. Thanks for joining us, everyone. This is a topic that we are really passionate about. On innovation and technology and how it can drive the legal profession forward. Last year at the Legal Innovation Week that was hosted by the Lawyers Hub together with Africa Law Tech, we did different reports and different studies on the uptake of legal technology in Africa. And we came to, very different conclusions on how, and very diverse thinking on how the legal profession needs to move next on legal technology. And so today I just want to talk about legal disruption and how COVID-19 has, acted as an accelerator towards getting the legal profession, to adopt technology. In 2019, I believe, we started using Zoom at the organization. And my first Zoom experience was with one of our partners. And so we paid for a Zoom account and somebody asked me, so what's Zoom actually? And in 2019, and it looked like something that was so far-fetched. Paying for technology is not something that people were doing. A lot of people were doing to pay for technology. We have these legal tech companies that were trying to convince African lawyers that you actually could buy, a technology that could either automate your process, make it easier to work, or even help you to read through stuff, document discovery and things like that. And so, in January 2020, we hosted a few events in Uganda, in Rwanda, in Kenya, and in Nigeria. And so we live streamed them on Zoom. And so people are asking, how are you doing this? What's this? And it looked like Zoom was something so strange. I couldn't make it to Nigeria myself for our event in Nigeria. My passport got stolen. And so I was stuck in Nairobi. But now you look at the past 1 year, we don't need passports. We are traveling to conferences everywhere without necessarily needing a visa. We are speaking to clients, and now Zoom has become a verb that you can say, I'm gonna Zoom, and so we've gotten used to the idea that you can get on this platform and meet people, meet clients. A few rules have been broken. Now we are trying to figure out etiquette online and how lawyers need to appear, before tribunals and courts, on their online platforms. We have had these conversations around, I think in Kenya, the running joke has been, my Lord, can you hear me? My Lord, can you see me? Because you can say, you're on mute, you have to, still maintain the decorum, even as you go to court. And so I think one of the things that COVID-19 has done is to really accelerate the legal profession, which nearly always comes last in adopting new technologies. If you've read the books by Richard Susskind, he's a really incredible, British lawyer and speaker, and now advises the Chief Justice, and he said this, that are we going to see an end to lawyers? He started speaking about artificial intelligence in the 80s and how the legal profession would benefit from, artificial intelligence. And so I think that if one lawyer thought through in the 80s that there was an opportunity for law and artificial intelligence then, I would look them up and read their books on what they think would actually happen to the law in a few years to come. We have some lawyers now who are in the blockchain industry. There's a great, sorry, I forget his name, but I'm gonna just bring it up. He talks about law, blockchain. He came up with the idea of contracts and smart contracts, on how contracts would happen on the blockchain. And so they have really incredible ideas on how to disrupt, the currencies and money as we know it, how we could disrupt contracts as we currently know it. And I think those are some books that we need to keep, reading and listening to the speakers and finding out exactly what the world is going to be in another 10 or 20 years, because they say COVID actually accelerated technology by 10 years. It will have taken actually 10 years for people to maybe get on Zoom, to get on other platforms like, some are not on Twitter or social media networks. Other people are using HubSpot and figuring out how they need to, do their client management systems online. We really hadn't gotten to that point. Even on research, it took COVID for people to actually realize that I need to cut down my costs. I can't afford every member of my team. And therefore we need to turn to technology to look at how technology would help. And so how is legal technology in Africa? I think one of the things that has happened in different countries, I know Nigeria had challenges with virtual courts, but for instance, in Kenya, virtual courts have actually accelerated the rate of tech adoption within the legal industry in Kenya. You have no option when you have to do your mentions online. You have to figure out, especially for senior lawyers, how do I get a laptop? How do I then, I know a lawyer who hasn't had a smartphone in years. His secretary used to have a phone and he would pick calls through his secretary. And now with the smartphone, he had to figure out, how do I have my own number? How do I have my own laptop and get into these particular hearings on my own? We have new challenges around privacy now. We've had, certain incidences where we go to see people's houses and rooms, certain mics were not put off in time, certain law firms were hacked, and there were, data breaches during this COVID-19 period. And so we need to really start thinking like hackers as well, that how do we play defensive and also offensive, that somebody does not come in to, compromise my client data. We've had, like banks and the big tech companies, they have something called buggy hunting, where you come in and they bring in techies and they come and try to do penetration testing within your system to just see how prone are you to being hacked and the data that you have for your clients. And so certain law firms are trying to do that already and trying to get out the tech ecosystem to work a little bit more with them. And we've seen that interdisciplinary work is actually really useful for lawyers, that we should not work on our own. We must look for other disciplines that we can work with to ensure that we are actually more efficient. And so in conclusion, we are looking at a legal profession that is going to change in terms of, one, a legal profession that is productizing. They say productify. Look at how law is a product rather than law as a service. What is it that you can actually put together that people can buy as a product? Number two, how do we learn from other jurisdictions that are now thinking through that the law needs to be, the law is just not for the lawyers, that other disciplines can come in and form a law firm and look at a problem as a tech problem and also as a legal problem. Somebody else can come in and look at it as a business problem. How do you solve these business problems? I think that makes us better lawyers. Compare the UK and the US, one where you're liberalizing the profession and also looking at, let's say, the state of Utah, that's looking at how do you conduct more research? How do you have, regulatory sandboxes and allow non-lawyers, just break the rules to see how far innovation can go, but within a controlled context, to see how this can help access to justice. So I think those are the discussions that need to happen. The changing role of the Bar Association now is more evident than ever. It's no longer the one that just the bar that will just self-regulate. We're also looking at the bar that will help you, get you to the next level of learning. How are you doing? Education, because now it's lifelong learning. It's no longer I did university and I'm okay with the knowledge I have. You have to keep learning, keep pushing, and bar associations must actually do that. Then bar associations will act as unions as well to look at how do you help your members to even get into negotiating tech deals, for example. How do we get on Zoom and not pay a fortune? Your bar association negotiates for that. If you need another tech platform, how is your bar association actually getting you there? And so I think we have seen, just a changing role of the lawyer, the changing role even of the client. Our clients are demanding more. They're demanding you to be tech savvy. They're demanding that you understand certain things. Sometimes they want you to pop up on Instagram Live and start advising them on Instagram Live. That's not what you are, taught that we need to do. And so I think the current lawyer must continue to learn, must hear the client, and must look at both the business aspects and the legal aspects of the problems that they're trying to solve. That's what I would say in a nutshell.
Sorry, I was muted for a minute. Thank you, Linda. That was really very insightful, and we're definitely going to have more time as the session goes on, so we dive deeper into those issues. I would really like us to do that. Professor Ojukwu is back on now. Sir, welcome, sir. I read your citation out when you were offline, and I'm sure everybody's really excited to see who I was talking about. So welcome, sir. Thank you.
Good evening to everybody, and welcome to PALU's conference. I'm to talk on two themes. One is on the impact of AFTA on lawyers in Africa, and the other one will be on the role of CLE, continuing legal education, in relation to the new regime, the African new regime. Of course, the impact on lawyers is clear. It will create more employment because there will be demand for more legal services. We surely will have to relax our cross-border legal services regime across countries. There has to be law reforms, lots of law reforms in each country. There will be greater use and greater need for the use of ADR and arbitration. Am I lost?
We're following you, sir.
All right. There'll be greater use of arbitration and ADR. And so more and more lawyers we need to get into that field and dominate it. There will be need to reform our court system and access to justice so that we will not be signing agreements that will be referring our jurisdictions to London courts. They will need to draw protocols in relation to legal services and get the countries append to those protocols that will allow easy cross-border legal services across countries. In terms of the continuing legal education program, surely CLE is the basis for capacity building at any time. For any development in legal services, we must continue to build capacity. But there's a problem in Africa which PALU must tackle as the pivot. First, conduct a study on cross-border legal services. What is the regime from state to state? At least a comparative understanding of what is required. Because as it is now, most African states, you can't move legal services easily, in spite of the free trade agreement. So the PALU needs to conduct that kind of research, and that's the only way we can use that kind of the result of that research to influence reform or changes under AFTA. And the basic continuing education program is said to be after graduation, post-graduation, post-call to bar, post-registration as a lawyer. We need to encourage the establishment of continuing education institutes by the bar associations in AFTA. And also, PALU has to run its own continuing education programs. We also need to encourage not only free legal services, we also have to encourage mandatory programs that will force lawyers to go and learn. Now, but before we get even to the continuing education program, we need to really develop our major legal services program in the training at the lower training levels at the universities. We need to develop studies and encourage introduction of specialized courses relating to AFTA, as it is in European Union, where they have specialized courses, European trade law, European human rights law, and so on and so forth. We need to have such also developed for our first degree programs and master's degree programs in universities. We need to encourage short-term programs in universities that deal with issues concerning the development of legal services under the free trade agreement. We need to encourage publication of books, materials, monographs, articles in journals on issues related that will influence legal services across border. And there are many areas where we can develop these ideas from human rights studies, from trade law, from investment laws, from tax laws, from IP protection laws, insurance, customs duties rules, dispute settlement mechanisms. These are areas we need to develop learning platforms, and PALU can lead that. I think that we can start with that kind of discussion in relation to continuing legal education.
Okay, thank you, sir. And I like that you kind of itemized all the different areas that need to come into play, but particularly in trade, investment law, IP protection law, because those are the things that really go into the African Free Continental Trade Area Agreement. And then also the fact that you mentioned the responsibility of bar associations and professional organizations generally in providing these opportunities. I think I would say that that's why PALU was very happy to partner with us on Lotrella to bring these legal tech, these coupons for our legal tech courses, because even you have an organization that can do this thing, that can provide this kind of information, having partners who they can also work with to get that kind of things directly to lawyers, just using their influence to plug it into lawyers is really critical and really important. So I'm very happy that you pointed that out, sir. Thank you very much, sir. So I will go over to another panelist. I would like to introduce another panelist. Our next speaker is a man who I found no shortage of good works to his credit. He is Mr. Stephen Karangizi. I hope I'm pronouncing that properly. Please correct me if I'm not. Thank you, sir. He is the Director and Chief Executive Officer of the African Legal Support Facility. Mr. Karangizi served as Deputy Secretary General of the Common Markets for Eastern and Southern Africa, COMESA, from 2008 to 2011. He's had a remarkable legal career spanning over 37 years. Mr. Karangizi has served as a legal advisor to the government of Antigua and Barbuda, Uganda, and Zimbabwe. He was chairman of the United Nations Commission on International Trade Law in July 2006. He is enrolled as a legal practitioner of the High Court of Zimbabwe and an advocate of the High Court of Uganda, among many, many other accomplishments. It's my absolute pleasure to have him here with us today. Welcome, sir.
Thank you so much, Naro, and my special thanks to the organizers, PALU. PALU, our partners for a long time. The very fact that I am attending this year is a sign that COVID has changed things, I could say, some of the things radically, because I've been missing all the conferences of PALU because traveling can be quite strenuous. This year, I'm happy to attend, and why am I attending? Because of technology. So in terms of the interface between legal technology and legal education, I think I'll talk about it broadly, and I'll talk about it as an interface. As a legal facility, we provide support to African countries in negotiating major agreements. It was obvious from the beginning that there was a dearth of information and capacity across the whole continent in certain areas of trade and investment, particularly private sector investment, in areas that are not taught at our universities. So from early on, we realized that we would be relying on international law firms for these services, but we needed to build the capacity of African lawyers in order to be able to level the playing fields for our governments when they are negotiating these major agreements. So we are talking of areas relating to mining, oil and gas, infrastructure, particularly PPPs, very complex, underutilized in Africa, mainly because of capacity. Power projects, what we call normally agreements concluded, power purchase agreements under power. And other issues like debt issues. So we started providing capacity mainly on a face-to-face basis, but they've always been expensive. 2 years ago, we said the continuance of this was not sustainable. So we started what we call ALSF Academy. All those who are participating, you can quickly Google alsf.academy and you'll see what we are offering. We started offering online courses in those areas. We added on a few more like dispute resolution, ADR, particularly arbitration. We also added on what we call personal and professional development because we realized that a lot of our law firms in Africa have not raised their game in order to be competitive. So while the business is still going outside the continent, we feel that we need to shift that and get the right professionals, right African professionals providing all these services. And we also realize that there are a lot of challenges in terms of enhancing the use of legal technology for education in Africa, the capacity building that Professor was just talking about just now. So we realized, first of all, most of the lawyers quite often do not have the resources to buy the necessary technology tools. Then secondly, the materials are not always available so that the lawyers can raise their skills. Then thirdly, the cost of live education is always more expensive than online education. And then the availability of relevant materials in all these areas. When you look at the materials available online, most of them do not relate to Africa. So we concentrated on building this platform to be able to provide these services. At the moment, we've already completed 6, the program will have 3 levels. So we've already completed level 1 in 6 clusters, the ones I mentioned, mining, oil and gas, and so on and so on. There's already a huge uptake, but it's not enough. And what have we seen? We have seen that there is interest in this course, in these courses. There's interest in these areas, which, as I indicated, are not taught at the university. And the more African lawyers have access to these materials, the more we increase their capacity and they are able to address these issues whenever there are opportunities for them. The courses will have a certification process and will have 3 levels: level 1, level 2, level 3. Level 1 would be like beginners, introduction, but it's still complicated. Level 2 would be a bit more complicated, and level 3 will be advanced. So you have a certification process. And we've already seen that there are challenges. First of all, one of the challenges we have is that African law firms have not yet started the process of integration. They are still small-based, with the exception of a few countries. I mean, Nigeria is one of the few countries where law firms started consolidating. So you have quite a few large law firms, which also provide enhancement of capacity of their staff and which makes a difference in the arena. Then secondly, another challenge we also realized is in the whole sphere of capacity building is that women are often marginalized. So in fact, we insist on parity in participation of these available capacity building processes for the women as well. Then of course, I already mentioned, we already saw that the competencies were quite low. So we also try to track those who do the courses and how they can enhance their capacity. And then I also indicated we try to make sure that they are relevant. Finally, in terms of linkages, we have ensured that we have done this with the African Bar Association, the regional bar association. So in establishing the relevant offices, we've worked with SADC Law Association, East African Law Society, and a capacity building institution set up in Benin for the French-speaking countries. Unfortunately, West Africa Bar Association has been inactive in this area, so they've not been participating, but we hope that they will be able to participate in the times to come. The arrangement and agreement we have with the regional organizations is that they would use this material for continuous legal education. So that's our expectation. So I have taken, I have concentrated on what we are already doing in terms of the interface between legal technology and continuous legal education, because I think that's the way to go. That's the way to go because there are probably three benefits that would come out of it. I think identifying that we have weaknesses in terms of capacity in all these areas, as the professor has already clearly said, that is very obvious. We know all that. I think one will be sustainability. The costs of live programs are just too high. We spent a lot of money providing capacity to lawyers identified by PALU in 2001, 2011, 2012, and it was just too expensive. So sustainability, the cost will be much lower. Secondly, knowledge transfer. You can track the knowledge transfer because every time you do a module, you have to do a small test on the module. And you cannot cheat because we have technology for showing that you're actually the right person that is doing the course. Then thirdly, evaluation, both when you do the courses and after you do the courses. So I think there is a unique opportunity. If we don't move online and encourage lawyers to start using the materials that we have, we are not going to have a paradigm shift in this area. We will continue crying about the lack of material for making this transition using legal technology. COVID has shown us that unless we use technology and on a legal basis, our colleague Linda initially identified the areas where we can start moving to, so I won't go into them. For instance, arbitration, we will start moving all those into legal technology. And finally, we all have a responsibility, I think Linda hinted on it, of working with our governments. That's a process that we have also started, to pass the necessary legislation that will create a better enabling environment for legal technology. So I hope that is a quick summary of what I think and what we need to do going into using legal technology for legal education and generally for the legal profession. Thank you very much, Naru.
Yeah. Thank you very much, sir. And indeed, I like how you've summed it up because it makes me grateful for the fact that I chose that we look at these things from three important perspectives, both from the AFC, FCTA, the COVID-19 pandemic, post-COVID business landscape and technology, because these three things together are what is creating, the pressure on us to work towards that future that we want. Like Linda said, looking at how technology is now, it would ordinarily have taken us 10 years to get here. But I think that the combined effect of everything together has, pushed us in that direction and made it much more imperative than ever for us to do that. So, well, I want to go back to, there's a comment here for Linda, which is from Professor Dawuni. She says, congratulations to Linda for setting up the Lawyers Hub. It's an example of women in leadership and pioneering the path for others. You have not allowed your sex, also known as your gender, to prevent you from pioneering in the field of both law and technology. And yes, congrats, Linda. That's really amazing. And it just, even feeds into the previous session of how technology, the role that technology plays in everything, really. And in continuing legal education, indeed, continuing legal education is key. Like everyone has just said, it ensures that lawyers remain competent in their profession. It ensures that they remain efficient and up to date. It helps lawyers broaden their knowledge and skills beyond the type of work that they already know to the type of work that is required by the present situation. Like Prof. and Mr. Stevens said earlier, capacity building, not having capacity building, not having the capacity to do these things, to participate in negotiations, to have equal footing with other, maybe other countries from other continents, when you're, or even just personally as a lawyer, when you're working with a client who is transacting with a client from another country, you not having the capacity to participate in that engagement is really dangerous for it's dangerous for your law, for your client, it's dangerous for you, it's dangerous for your country. I mean, in a world that is changing so rapidly, in this world where technology continues to disrupt business, law, and governance, lawyers more than ever need continuing legal education. And then if you add to that the emergence of the African Continental Free Trade Area and the post-COVID-19 business scape, like putting all three of them together and all their associated changes, the ability of lawyers to continue to build on their knowledge is crucial to the development of a country. There's a popular saying that no nation can grow beyond its level of education, and I completely agree with that. And for lawyers in particular, lawyers are social architects by nature. They support business and governance in so many ways, and the progress they bring contributes greatly to the overall growth of the country. And it also works in the reverse. I mean, if lawyers are not supporting these things, there's very little growth. I think if you actually look at countries where they have a small number of lawyers, specializing in different fields, you will see that they are largely, less developed than other countries. So I would just like to go around again, and I think we do still have some time before I go on with the Latrella presentation, but I would like to just go around to the panelists and give you some more time to expand on some of those issues that you addressed. Like, for example, Linda, you were talking about smart contracts and the role that blockchain, the role that lawyers, or rather a lawyer who had tried to use blockchain to create smart contracts. And I think that that's very wonderful. I'm more curious about it in light of regulation. Ideally, blockchain and cryptocurrency is generally regulated according to what it's being used for. If it's being used as a currency, CBN will regulate it. If it's being used as a security, the Securities Exchange regulator comes in. So how do you think that will work? I mean, much of this is theoretical because we haven't seen it much in practice yet. But it's very good to have a good idea of how it will work in practice. Well, what do you think?
I think I'll maybe make a general comment and maybe touch a little bit on blockchain. And I'd say this: I wish I was taught when I was younger how the world works. Because I think even in law school, we are not taught enough how the world actually works. And so you come out looking for this perfect world, this perfect client, perfect practice, and it just doesn't exist in light of disruption. Every single day, there's always something that disrupts you. I was gonna make some quotes about the wild. They say that the slowest deer must be faster than the fastest lion on any given day, something like that. And so every single day we have this disruption always chasing us, and we must always be faster. That way you don't get disrupted. And so I think within the legal profession, what has been lacking is that we've been cushioned from these disruptions because of regulation. And so somebody comes in and says, I'm going to disrupt the tech industry, the legal industry. And so what do? We stop them at the bar association level and say, no, they don't have this. And so let's stop them. But regulations can only cushion us for so long. Eventually, everybody will give in. Members of parliament, if that's the body that makes the laws in your country, jurisprudence will start looking at, what's a human-centered approach towards justice? And can we go with it in that sense? And so I think that we need to sort of let go and just see, whether it's going to give us more money or not, but does it actually bring in justice to those who actually need it the most? And then now we come to the question of blockchain. Blockchain always, any new disruption sort of sounds like a cult. When you hear about it, you're like, oh my God, these are people, it's this sect, there are few people, they're doing this, it's not gonna work. And so the government of the day may issue a warning. Like for instance, in Kenya, the central bank governor issued a notice and said, cryptocurrencies are not legal tender. And so they said people need to be careful about it. Meanwhile, you'll have, banks like in China who are already trying to look at what's the place of digital currencies. Just this last week, there was a discussion at the World Economic Forum in Davos, which was online this year. And that's slowly talking about what are the regulations around digital currencies and what should governments do, And so I feel, and tying into what I said initially, is that people will buy time as they buy more crypto. Especially regulators, they say, no, don't do this, but they're actually the ones who are, trading in crypto. Nigeria, Kenya, and Nigeria is leading in Africa. Actually, I think the second in the world in trading in cryptocurrency after the US. And that tells you that there's actually something going on that we must be interested in. And so someone gave me some really cool advice and said, if you advise any startup, which is trading in blockchain or whatever it is, ask them to pay you in cryptocurrency. You have nothing to lose. And then we will get into Bar Association saying, why are lawyers accepting cryptocurrency as payment, and we'll get into all the regulatory requirements. So what's my general rule of thumb is this: the regulation will protect you just as long as it will last, but eventually people will actually disrupt the usual systems. A night ago, I think in the US, I don't know if you read this about Wall Street and what people did on Reddit. They came in and figured out this is how Wall Street makes money, from selling bonds. And so they did memes around a particular company, and they went and outtrained the system. And some of them became billionaires overnight. And some companies and hedge funds actually are now in losses, and some have gone to borrow up to billions of US dollars. So that's what this next generation can do. I think the lawyers should think in terms of, my next client is a Gen Z client. They're digital natives. They're not going to look for a lawyer on their website. They don't care about your website, which is a good lead, but they want a lawyer who they know on Instagram. Sometimes you look at them as young people, but they're going to inherit their parents' businesses. If their parent, for example, was the rich one, they're the ones who will be running these businesses. And so they're looking for lawyers who actually understand them and understand their terms, Tech startups, for instance, in Nigeria, we have this startup, it's called not Stripe, that raised $200 million. And they're young people, they're barely 30, and they've raised $200 million. And now lawyers are like, I wish I was representing these startups. So that's the new generation of wealth. And it's not maybe the other generation that had oil and gas and things like that. And so what can we do as lawyers is to quickly learn and understand your client and say, this is the next generation. This is what they're playing with. This is what they understand. Their timelines are pretty short. Their attention is pretty short. They don't want you to send them a legal alerts. We're sending 10 pages. They simply want a TikTok. You do this, you do that, you do this, and in 1 minute, they have the facts, the full facts of the case. And so I think this generation, and especially the older lawyers, must look at how do you work with young lawyers to ensure that your law firm is still practicing the traditional way, but embracing technology and embracing innovation in how you present your products so that you're not out of the market. Because very soon, young lawyers are going to make more money from the legal professions than the older lawyers made before. My final comment in how do we move ourselves out of this? I talked about lifelong learning, and I like what Donald Dare has put on the chat, about how do you productify, and two, how do you also have lifelong learning? There's so many websites now, and LawTrailer have shared what they're doing in continuous legal education. We have Lawyers Hub that has content, like on YouTube, and this is a plug. Please go to YouTube and look for Lawyers Hub Kenya. We have content on blockchain, on artificial intelligence, on tech products that you could use, like every single thing. You have actually no excuse. And so if you really wanted to grow and learn, don't spend your weekend watching Netflix unless you're watching The Social Dilemma and things that would actually help you learn tech policy, for example. Go on those websites on the weekend and watch the videos, keep learning. I know lawyers don't like to admit what they don't know, but just go online and slowly learn those things and come in and start speaking. And if it's a tech company, for instance, you're representing Google, they will give you more work because they see that you understand their context. You know, sometimes we come in and people ask you for advice, and the easiest thing to do is to throw 20 pages at them. And this generation does not want 20 pages anymore. They simply just want, what's the problem? And give me the business solution as well. Does it make, you know, monetary sense for me to get into this? I think if we keep learning like that, you go in on Udemy, look for courses that would be able to help you. Harvard Online has really good courses that sometimes you just pay. It's nothing actually, you don't pay anything. If you need a certificate, you pay $200. Those are the things to do. If we don't do that, there will be another either infodemic or pandemic, and then you realize actually everyone moved. You are the only lawyer who didn't know what was happening, you know. That's what I would say. Thanks, Naro.
Thank you. Thank you so much, Linda. That was all very, very insightful. Specifically on the point on startups, I think I have a very interesting experience on that, because here at the law firm, we do work with startups. And I think that I realized maybe after the first 1 or 2 tries, I realized that nobody was going to read my 20-page briefs. And so we just shook it up, and we, you know, took our conversations to Instagram. We have Instagram live chats. We, you know, do threads on Twitter, and, you know, we're always online doing TikTok. And that is how you get people who are in that space to jump up with you. And it's really a large part of the Gen Z crowd that makes up that space. But the thing is, regardless of what generation it is, their purchasing power is increasing greatly. That's why I like the fact that you mentioned the Wall Street situation, because, you know, you have a couple of nerds on Reddit just talking about how, oh no, so this is how the stock market works. And then you realize that people that young have the power to make the kind of impact. They shook Wall Street. They have the power to make that kind of impact just from chatting on social media, you know, pressing your phone. And so having that together makes me just remember, I think I first started to hear about legal technology maybe towards my final year in the university. And I said, okay, when I come out of here, I'm going to specialize in legal tech. And then I came out and I was just looking, and there were so few options for me, you know, to specialize. I could see courses online from different countries, but none of them quite spoke to the legal and business context the way I would have liked. And I think that that's a big part of why we're doing Lotrella, so that we can, like Mr. Stevens said earlier, they have all this knowledge in different places. They have experts from so many places, you know, just working together, but being able to disseminate that knowledge to as many lawyers across Africa, that is the plan, that is the goal, that's what we're trying to do. So let me let Mr. Karangizi just come and give a closing remark, maybe to just build on any of the things that you had said earlier.
No, thank you very much, moderator. I think the points have been made. My only closing remarks are that the law associations need to embrace legal technology more. And you have raised, Linda especially raised something that we take for granted.
I so wish.
Unfortunately, the legislators, I mean parliaments and policymakers, governments, are 5 steps behind where we need to be in terms of legislation necessary to enable greater use of legal technology. So our laws are still deficient. It is something that as law associations, PALU, we need to push for. So you're talking of data security, laws relating to data security, laws relating to data privacy, laws relating to electronic commerce. We cannot talk about AFCTA if we don't address deficiencies in many of those laws. So we need to push for many of those laws. I'm sure you've already seen there's a big collision between the younger generation in what they are trying to use and the public institutions. So I think that's the thing. If it was not for instance, mobile money, there being a revolution, we would not be where we are now, where you have an interface between mobile money and banking and creating the whole fintech industry. And all that needs enhancement of our legislation in order for us to take greater advantage of it, especially the younger people. So there is still a lot of room, and I think it is very clear that opportunities are very many. So thank you very much, moderator.
Thank you very much, sir. Thank you. So I will just go on quickly to go through the Lotrella presentation. So Lotrella, so for those who may have missed it earlier at the beginning, Lotrella is it's a platform that is enabling continuous professional development, co-working, and networking for lawyers all around Africa. My name is Naro Omalsage again. So at Lotrella, we're using technology to build a knowledge sharing community for lawyers across Africa. The platform itself has a number of different sites which offer different features and services. We have a legal document sales service where you can instantly purchase, you can just instantly download a document. And it even goes into something that Linda said earlier about creating legal products, which is something that we have done here. We've created it in such a way that any lawyer can write an agreement, put it up here, and anytime anybody purchases that agreement, the lawyer, gets some income from it. So that's one way that you can solve that problem. You can also see on Lotrella, we have directories for lawyers and notaries publics. You can come on, you can see lawyers practicing in different fields. You can find a notary public, in your area or wherever you want to go. We also have an e-commerce site where you can buy and sell books, courseware, law reports, and everything. Technology has revolutionized everything, including access to education and continuing legal education, how we learn. Although unfortunately, the legal sector has been a bit slower to adapt than other sectors, like for example, finance and technology. It is a traditionally cautious sector. But at Lotrella, we took this personally because lawyers need more flexibility and options in how they develop themselves professionally. Continuing legal education should be available, accessible, and most importantly, affordable to any lawyer who wants it. There are CLE events and programs like Professor Ojukwu mentioned earlier. There are CLE events and programs, provided by institutions. But like he said, we need more of those. CLE should not just be restricted to cities like Lagos and Nairobi and Johannesburg, whereas there are lawyers all around Africa. We need affordable skills training available to all practitioners, regardless of where they are on the continent. And that is what we're trying to solve with Lotrella. So on Lotrella, we have courses on corporate law, ethics, compliance, technology, internet infrastructure, blockchain, legal data analytics, and so many more. You can just simply log on to lotrella.com, click on e-learning, select a course, and start learning at your own pace. It's seamless, simple, and easy. And we also have a French version of the site. You can change it from English to French. And we are working, of course, on expanding into more languages so we can serve as many people on the continent as possible. There are two important features of our e-learning site, which I would like to share today before I round up: course creation and virtual classrooms. So with course creation, anybody can create a course on Lotrella from wherever they are. So we have specialists in so many different areas of law all around the continent. And, just the idea is that they can take their knowledge, put it together. In Lotrella, we have an in-house course development team that will just take your text, maybe you write in text or you write it in slides. They'll just take that from you and create a fully online, fully plug and play course, which anybody can take from anywhere. And this is open. The course creation is open to anybody who is a specialist in their field and is interested in sharing that knowledge, both to earn income and to make impact. The course creation button is right at the top of our e-learning page. So you can just click on it, follow the procedure, and start to create your own course. I mean, the idea is that we can't have so many brilliant people on one continent, because Africans are really talented. I was at the PALU conference last year, where I got to, physically interact with lawyers from everywhere. And, I was just amazed at the depth of knowledge that we have on this continent. And it was one of the things that birthed this desire to, find a way that everybody they can push out that knowledge. I mean, we have institutions where you can go and learn these courses and take it, but with COVID-19 and with the speed at which we need to learn, the fact that we need this learning to be flexible, online learning is the easiest way that you can solve all of those problems. So the second feature is our virtual classrooms service. So with virtual classrooms, institutions and organizations and even individuals, they can use our live streaming facilities to create a virtual classroom, like a real life classroom. It's just that this one can take an unlimited number of students. They only need a phone or a laptop to join in, simple internet connection, and they're in. So just like a typical classroom, with a virtual classroom, instructors can send out notifications to students. They can, get students enrolled. They can even give assignments right here on the site. They can give in-house assignments. They can grade students online. So imagine all the things that we could do with that. Our virtual classrooms has a variety of lesson formats. You can choose to give your classes in text, in video, or slides using the live stream function. You can create quizzes, like I said, you can create quizzes and tests for your students, and it is convenient. There are no limits there are no restrictions on knowledge anymore. I mean, with COVID-19, I think one of the most amazing things that I learned personally was how I could be, like Linda said, we have traveled everywhere from the comfort of our homes, how I could be in one webinar in Paris and another webinar in Nairobi and have those two things not even interrupt my everyday life. So that's one huge advantage that has come with the acceleration of technology. And we want every African lawyer, as much as possible, as many people as possible, to benefit from that. So imagine all the things that we could do with that. The idea behind our platform, behind Lotrella, is that using these two tools, course creation and virtual classrooms, we want to create a knowledge sharing community where lawyers from different parts of Africa can put together their specialist knowledge, perhaps on local law, on their various local regimes, and share this knowledge with lawyers from other countries. And in doing so, create opportunities for themselves. For example, by the time legal services start to trade, by the time you see more lawyers moving around, supporting clients in different countries, there has to be a quick way that you can easily get information on a subject. A course on Lotrella can be completed at your own pace, but if you do want to do it instantly, 2-3 hours, you have run through the entire material and you're all the better for it. And this could also help us, I believe, this would also help us in collaboration on different levels. Like, for example, in starting advocacy projects. So for instance, if I am working on a cross-border trade with a client in Tanzania and I notice an aspect of law that I didn't know before, and I can get a course on that aspect of law from a lawyer in Tanzania and just learn it online, and I learn how that policy works, I can go ahead to take that knowledge and promote adoption of the same kind of policy here. So these are just some of the many things that we can do with this. And for the AFC FTA, it means that we can do so much together without even being together. I don't think that there's any one industry with the obligation to make the AFC FTA work as much as the legal industry. Like I said, lawyers are society builders. We are social architects, and it's on us to build this global powerhouse of a continent that we're trying to build. And with technology at our fingertips, there is no limits to what we can do. So I'm going to stop here and spare some time if there are any questions. There are lots of accolades in the chat, and I'm very thankful. I think on behalf of every participant, I'm very thankful for them. But if there are any questions, I can take them. But thank you all very much for being here. And I will just hand over to Dawn to handle that aspect. Hello, Dawn. Hello, is Dawn here?
sorry, we lost Don for a few minutes. He's saying he's just coming in on, but thank you very much.
Alors, je peux prendre le relais pour Don.
Thanks, Naro. Thanks.
Thank you very much, Linda. Yes, I think Fathia is speaking.
Donc,
Hello, Fathia.
Oui, effectivement, je crois qu'on est arrivé à terme de cette session d'aujourd'hui. Je félicite tous les participants, tous les panélistes. Je réitère mes remerciements pour leur intervention enrichissante. Et je vous demande de participer également demain à la même heure, à 14 h, heure de Nairobi, pour continuer avec nous les travaux de notre conférence. Merci encore une fois et à demain.
Actually, see you tonight. In another 2 hours, we are going to have the quiz night. And so it's International Data Privacy Day. We have a very impressive, we have a game, we have prizes. If you want to test your knowledge of data privacy, if you want to meet a few people within this room, please join on this same link. It's going to be at 7:30 Nairobi time. So if you can join us between that time, it's 7 p.m. Nairobi time, 7:30 Nairobi time. So the link will be open. Please join in. We'll be having such good stuff to give away.
Félicitations pour ton acharnement. OK, on n'y manquera pas.
OK.
C'est bien noté. Alors, j'invite les participants à cliquer ce lien qui vient d'être indiqué par notre panéliste. Merci beaucoup. On se dit sur ce, au revoir et à demain.